In this third section, we take a look at China's regulations on its overseas contracted construction business. The question being, how does China manage to regulate and keep companies in check to ensure optimum productivity and best practice? In the previous section, we discussed China's supportive policies for foreign contracted projects and looked at the plans that China has put forward to improve the quality development of foreign contracted projects and the industry at large. However, in the course of contracting projects abroad through the years, to their detriment, some Chinese enterprises are falling short of what's considered to be best practice. For example, in 2010, China launched a special inspection campaign to review foreign contracted projects. In the course of the review, it was found that the North Sichuan Cyberport Construction Company Limited was being investigated for labor disputes arising from its projects in Tajikistan. Early March 2011, almost a year later, the company had another labor dispute of the same nature. After the dispute broke out, the Ministry of Commerce asked the relevant departments in Sichuan province to take effective measures to solve the problem once and for all. A panel group composed of relevant stakeholders from the province set off for Tajikistan on the 7th of March 2011 to deal with the situation. The provincial department suspended the operating license of the said company in accordance with the regulations on the administration of contracting projects abroad. The need to standardize the process of operation on foreign contracted projects and promote a healthy development of the industry led the State Council of the People's Republic of China to formulate a series of regulations on the administration of foreign contracted projects. The Decree number 676 of March 2017, as amended by the State Council. This seeks to serve as a general guideline for every project going forward. Let's briefly look at what this contains. First, let's examine the do's. These are a set of guidelines that a company is expected to fulfill in carrying out their construction obligations, such as the unit contracting the project abroad shall conclude a written contract with the contractor of the overseas project, clarify the rights and obligations of both parties, and perform its obligations in accordance with the contract. Agency units contracting the project should strengthen quality management for safe production and execution, while establishing, improving, and strictly implementing the rules and regulations for standard management of the project. Next, there are the do nots. Chinese companies are expected to avoid these instances to the best of their knowledge and not compromise their business integrity. For example, in a case where the project is subcontracted, it shall enter into a special project quality and safe production management agreement with the subcontracted unit, or agree in the subcontract on the appropriate project quality and safety production management responsibilities. It should coordinate and manage the project quality and safe production of the subcontracted units. Another is that units that contract foreign projects shall not subcontract the projects to units that do not have the required qualifications prescribed by the state. The construction part of the project shall not be subcontracted to domestic construction enterprises that have not obtained a safety production license in accordance with the law. Also, the unit contracting the project shall expressly stipulate in the subcontract that the subcontracted unit shall not further subcontract the project and will be responsible for review if necessary. Lastly, units contracting a foreign project shall not collude in bidding at undue low prices or engage in commercial bribery. The next guideline looks to address the issues around labor contract and safety management. It states that the unit contracting the projects shall, in accordance with law, conclude a labor contract with the foreign personnel it recruits, provide working conditions, and pay remuneration in accordance with the contract, and should perform the obligations of the employer. Contracting units shall have special safety management institutions and personnel responsible for protecting the human and property safety of the individual to be contracted, and shall, in accordance with the specific circumstances of the project contracted, formulate plans to guarantee the safety of the employed. Units contracting projects shall, in accordance with the security situation in the country or region in which the project is located, conduct targeted safety and prevention education and emergency knowledge training for foreign personnel to enhance the safety, prevention awareness, and self-protection capabilities of the personnel. These guidelines will help to further prevent potential hazards and keep liable damages to bare minimum. Next is the compliance to having a reserve fund. This is to be used in the case of an emergency or unforeseen circumstances. The guideline says that units contracting a foreign project shall, in accordance with the provisions of the competent Department of Commerce under the State Council and the Financial Departments, deposit and pay the reserve fund in a timely manner. The reserve fund shall be used to cover the following expenses that the units of the external contracting project refuses to bear or cannot afford. 1. The remuneration of the overseas personnel. 2. The expenses required for the return of the overseas personnel or other relief expenditures in the event of an emergency. And 3. The expenses required to compensate the foreign personnel for the losses they have incurred. The Chinese embassy also plays a role, seeing as it's the first point of contact for China's contracted construction companies overseas. According to the guideline, upon entering into a contract between the unit contracting the project and the contractor of the overseas projects, it shall promptly report it to the Chinese embassy in the country where the project is located. The unit contracting the project shall comply with the guidelines of the Chinese embassy in the country where the project is located in the areas of emergency prevention, project quality, safe production, and protection of foreign personnel. Units contracting projects abroad shall formulate contingency plans for emergencies, and in the event of an emergency abroad, they shall promptly and properly handle the situation, and hereinafter immediately report them to the Chinese embassy and the relevant competent domestic authorities in the country where the project is being held. The Department of Commerce, under the State Council, shall, in cooperation with the relevant departments, establish and improve on the procedures for early warning, prevention, and emergency action in foreign contracting projects, in accordance with the principle of both prevention and execution. The Chinese embassy will assist companies in this regard. For the growth of the industry, trend monitoring, identifying development areas, and acquisition of more knowledge, reports on foreign contracted projects are also necessary. Units contracting foreign projects shall report regularly to the necessary departments, such as the Ministry of Commerce and the Statistical Department, on the implementation of foreign contracting projects and business statistics. The Department of Commerce under the State Council shall, in association with the relevant departments, establish a system for collecting and disseminating information on foreign contracting projects, while providing information services to other contracting units for foreign projects free of charge. The relevant departments shall, in such aspects as customs clearance of goods and entry and exit of persons, provide fast and convenient services to units contracted for foreign projects in accordance with the law. If any firm is found to have been guilty of breaking these laws and regulations, there will be legal actions taken against them. While some holds financial penalties in substantial amounts, others will lead to a total revoke of the operating license of the said firm. For example, let's take a look at these scenarios. If a unit contracting a foreign project has one of the following circumstances, it shall be required by the relevant department to make corrections and shall be fined between 100,000 yuan and 200,000 yuan. The superior person in charge of the project shall be fined between 10,000 yuan and 20,000 yuan. If there's a construction safety accident or other serious consequences costs, the department may lower its qualification level or revoke its qualification license. If they refuse to make corrections, the administration may prohibit them from contracting new projects for more than 1 year and less than 3 years. This and many more instances are how the Chinese government has put measures in place to ensure that firms are held accountable and liable for their actions.